recognize Mr. Gohmert, who was someone who recognized this situation very early on, for 5 minutes.
Thank you, Mr. Chairman, and I appreciate the witnesses being here. And yeah, I'd filed a bill last Congress, but I'm curious, if we passed a bill in the House that says it is the sense of Congress that the Affordable Care Act, and it's really hard for me to use those words, Affordable Care Act, because it's put constituents of mine out of work. It's taken some from full-time to part-time. It's taken away the insurance they liked. It's taken away their doctors they liked. So it's anything but affordable. Nonetheless, we'll use the misnomer that was used to name the bill. If we say in our resolution, and it passes, that it's the sense of the House of Representatives that the Affordable Care Act did not originate in the House, isn't that something that could be taken up and considered with judicial notice at any level of the proceedings?
No.
All right.
The answer is flatly no, because the courts never look at post hoc legislative history.
All right, but
I disagree.
All right, let's hear your.
So would I, because I argued one case that did.
It wouldn't be part of the legislative history of the act, so it wouldn't be. But I don't think that it would be valuable for that purpose. It would be valuable for a very different purpose, and they ought to certainly pay attention to it.
Okay.
And that's because it would discourage the court from punting its responsibility and saying this is a political question. Now, the Supreme Court in Munoz-Flores said they can't do that anyway. And so that's the more important reason why I think Mr. Onyx wish that the courts not examine this horrible act will fail.
Okay.
But I think if the reason that they would care in administrative law, if two agencies disagree on a matter, they don't defer to one or the other.
Right.
And so it would be some proof
an
that your reading
that
of the rules is different than what happened in the last Congress.
That there is a question of fact in this. So I was really surprised as a former judge and Chief Justice. I'm just shocked that anybody that claims to have knowledge of the law would have such a quick answer of no. But Mr. Kavanaugh?
Yeah, no, the court would certainly look at a resolution passed by the House on this for this important purpose. Whether or not the members of the House could bring the case themselves and have standing, that might in fact give them additional what it's called legislative standing. But now that we have plaintiffs already with standing, by having this resolution passed, it gives the court more impetus to look at this, because now it's an institutional interest being raised by the House that the court can't just simply say, oh, there's just some plaintiff. Why should that plaintiff worry about what the House has built? They basically relented, et cetera. So the blue slip procedure is an important procedure for the House to use. And Mr. Otte asked, well, why wasn't it used? Well, he was the counsel to Speaker Pelosi at the time, and he knows very well. The bill came over from the Senate. Speaker Pelosi says we have to pass the bill.
Well, let me give you a little help there. Actually, what had happened, the House had originated a bill, an Obamacare bill, and had passed the House under Speaker Pelosi's leadership. And I've had senators tell me that actually they were told that, look, we're passing the Senate bill, but everybody knows this isn't going to be the final bill, so we know you have some objections. Don't worry about it. Just vote for it. We'll clean it up later. And then Scott Brown got elected, so there was not going to be a chance for the Senate to vote for the House bill that originated in the House. So the only way they could do it was to conspire to subvert the Constitution. But my time's running out, and I have one more question to ask. Here is the original H.R. 3590. Being enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that's the enactment clause. And then it talks about the Servicemen's Home Ownership Tax Act of 2009. This is the bill. These are the topics, this little 3-page bill. And then this starts by saying, strike out all after the enacting clause. Tell me, where in this bill any of these topics in this bill were ever found. Any witness that cares to tackle that, point me out anything in the new bill that was in the old bill. Mr. Schmitz?
I can't speak necessarily to some of those issues, but I can say on the history of the clause, that sort of amending procedure was never contemplated by the public when they signed as on other bills, when they ratified it. There was one member I could find in the entire documentary history of the ratification of the Constitution where a member in the Virginia legislature, an anti-federalist during the debates, contemplated the fact that the Senate might abuse the amending power by trying to turn it into an origination power. And luckily, during that debate, Madison just so happened to be there, and he responded to the criticism that the Senate might abuse this amending power and turn it into an origination power. And he said, the criticism by the honorable member is that there's an ambiguity in the clause. And he said somewhat dismissively, he said, the first half of the clause is sufficiently expressed as to exclude all doubt, i.e., all revenue-raising bills will originate in the House of Representatives. That was the one time this was brought up among 34 different instances in the ratification debates I researched. And when it was brought up, Madison himself, who called this power the most complete and effectual power with which any constitution can arm the immediate representatives of the people for obtaining a redress of grievances, he dismissed it and said the first half of the clause is sufficiently expressed to exclude all doubt. The ratifying public had no idea. They would never have expected that that amending procedure would have occurred and that they were consenting to that. And furthermore, it was illegal under the Continental Congress since 1781.
Thank you, Mr. Gohmert. Thank you, Mr. Schmitz.
Mr. Chairman, I take it by the lack of any of the witnesses to be able to point out any topic in here that amended anything in our little 3590 bill. There is no such amending topic. And I yield back.
Thank you, sir.